Oh, hello. Yate KQBM Community, Blue Mountain Community here, California. Yate to all of you Miwok and surrounding clans and tribes, clan mothers, headmen, community, and here is a youth coalition program here near this radio station. I saw it there today and was observing this little community and this little radio station here. So thank you for welcoming me back again, KQBM.org, and to Juniper and to Alpa, and also my condolences to your family and um, also to your clan out there in the homelands. So that's it. Also to my relatives, the Shikero yate the Nashiniki Shas Kahasilo Kude ate Hinti Halianiki the this is and Baha one bit the Shnisha Shaya where they do some court cases in the federal Otahiki audit circuit court ko AD at ba Jihadish Alto AD at Bahadish Nehanson Kude California kan has holye the is ko Sacramento de a day one that's a holye that a capital ko federal court ban Nixos did this court case ended up in a federal court case. I was here in December the 12th since I visited with all of you here a couple of months ago, and since then I wanted to say again thank you for everyone's prayers and support. Shake your hand. All of you, across the World Wide Web, social media. Um, it's been a few months that they have taken time to review the complaint. It was in a complaint of a constitutional nature violation of Article 6, Section 2, in that article and the Bill of Rights is those area the foundation of the Constitution. And I was trying to share how I was doing it with the West Coast and also with all patriots who um, fight and take oaths to the Constitution for a peaceful coexistence with us here on Turtle Island. And one main thing that I did is I cite a two-row wampum treaty belt. It's still right here in my possession. I carry it here on my back and take it to the court and I take it to these capital, the Adabanesi. I stand with them there in the light and I have written up a complaint that was the violation of that two-row wampum treaty belt. And I added on a lot of affidavits of past precedent court cases that I have personally done, been involved in, all the way up to a genocide case being filed in states of Oregon, of New York, of New Mexico, of a lot of states South Dakota has arrested me on federal land. Um, Arizona, Navajo Nation, Pueblo, Taos Pueblo, all a lot of places, including the first time that became a historical precedent case was out of Oregon. And the state of Oregon, the people of the state of Oregon versus John Doe, Emerson Joe, they made it a case against that entity. This is the same similar case as that case in Oregon to the case in New York and also all the way back to Kansas to New Mexico. And there are a lot of cases that the same way this happened. It happened here again, where it is the people of the state of California, and 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 I took it to the federal court on November 18th. So since November 18th to today, I've received a letter, and that's what I wanted to share with you all was what their response is after they reviewed this complaint to see if they will take the case. I guess that's what it means, and so it's right here in this letter. Hold on. And it is in the United States District Court for the Eastern District of California, number 224-CV-3185-DC-DMC order. And Nii Nee is the plaintiff versus California State et al. Defendants. Any of you who have been following this court case out of Mount Shasta into Siskiyou Superior Court, October the 23rd, I think it was the date that the incident happened, and so all the way up to now, 5 months later into this is the order that this judge put out. um, Dina Kogan, let's see what it is. Kota. So it says the plaintiff who is proceeding pro se brings this civil action pending before the court is plaintiff's original complaint. Number one, the court is required to screen complaints by and brought by litigants who, as here, have been granted leave to proceed in forma pauperis. 28 U.S.C. Section 1915E2. Under the screening provision, the court must dismiss a complaint or portion thereof if it, number one, is frivolous or malicious. 2. Fails to state a claim upon which relief can be granted. 3. Seeks monetary relief from a defendant who is immune from such relief. 28 U.S.C. subsection 1915E2A and B in parentheses. Moreover, pursuant to Federal Rules of Civil Procedure 12H3, this court must dismiss an action if the court determines that it lacks subject matter jurisdiction. Pursuant to Rule 12H3, the court will also consider as a threshold matter whether it has subject matter jurisdiction. Number one, plaintiff allegations. Plaintiff filed the original complaint on November 18, 2024. Number one, plaintiff asserts that the basis of jurisdiction is federal question Article 6, Section 2 of the Constitution and the two-row wampum treaty belt. And diversity jurisdiction because plaintiff asserts that he is a diplomat. I'm still here in that capacity. The diplomat number is international diplomat number 13-032. Hear ye, hear ye, hear ye. To all entities, are you awake? Can you hear me pretty good? I'm putting some truth in your algorithm ears. Rewire you today. But this is what plaintiff seeks 666-000000000000000 in damages and criminal charges for treason. For treason. See at 5 and 6. Plaintiff contends that his cause of action arises under Article 6, Section 2 of the Constitution, the two-row wampum treaty belt, international treaty laws, U.S. treaty laws, and Vienna Convention treaties of 1868 at 5. In addition to the formal complaint provided by the Eastern District, pages 1 through 6, plaintiff attaches another form complaint of unknown origin. It is called a criminal complaint, all of you. A federal criminal complaint under 18 U.S. Code, subsection 4. Plaintiff attaches another form complaint of unknown origin. It is called criminal complaint. Federal criminal complaint for treason, violating the two-row wampum treaty belt, where I am a supreme authority, higher than the federal judge. Pages 7 through 16. A statement of certification for Cuba, page 17, and apostille, page 18. In the formal complaint of unknown origin, plaintiff contends that the Mount Shasta Police and Siskiyou Sheriff's Department unlawfully kidnapped and arrested plaintiff, and while in custody, plaintiff was assaulted in the booking area, and he was not read his Miranda rights. See at 8. No other facts are provided. Yes, there are no other facts because this Siskiyou Sheriff's Department is not forthcoming of evidence, camera footage. But he is named in this complaint. On November 27, 2024, plaintiff filed Exhibit C number 3. This filing contained a transcript. This filing contained a transcript from a preliminary hearing on November 12, 2024 in the Superior Court of Siskiyou County, pages 1 through 33, and apostille, pages 34 through 37. Another statement of certification for Cuba, page 38, it's out of Oregon. An irrevocable covenant power of attorney, in fact, pages 39 through 40. An apostilled affidavit, page 41, 42. On January 11, 2025, plaintiff filed a notice of stay of proceedings alleging fraud upon the court. Supreme Court Supervisor Simone Volz. Yes, fraud upon the court. California Supreme Court Supervisor Simone Volz and Max Alfaro, and the president supervisor of that branch of corruption over there out of San Francisco Supreme Court. And that's in number 7 that I did file all these things over there. Page 1. On January 14, 2025, plaintiff filed 2 certificates, proof of service documents. 89. On March 24th, plaintiff filed an exhibit which contained the same transcripts included in the original complaint. Number 10, plaintiff filed an acknowledgement of the receipt of 3 CDs. Number 11, 3 CDs are audio files of the 3 times that there was a Judge Bitchego. She's the president judge president. I don't know how you get president judges. But there's a president judge president out of Siskiyou Superior Court, and supposed to be retired. Now she lost all her retirement, maybe a house on the streets. I don't know, but that's what happens when you gamble. And so Bichego, Judge Lawrence, and that's the vice president, and then this T.J. Linville, all up for retirement, and they were all planning to go out with the bang, on Nii Nee. So they don't like it that I put they call it a frivolous amount on that. 666, 15 zeros. So anyways, on this, continue on. Let's see. Oh, the 3 CDs are, yes, the audio file. So and a bunch of court cases in the past. The court finds that the claims presented in the plaintiff's complaint are frivolous and will recommend that the action be dismissed with leave to amend. So all of you that speak slave, go look it up in your Webster's Black Law Dictionary, what means frivolous and what it means to dismiss with leave to amend. Anyways, it'll explain it here too. So discussion part 2. A claim is legally frivolous. Oh, they're going to explain it right here. Okay. A claim is legally frivolous when it lacks an arguable basis, either in law or in fact. See Nitsky versus Williams, 490 U.S. 319325. in the year 1989, and also in case Franklin versus Murphy, 745 F2D 122, Ninth Circuit, 1984. When applied to a complaint, the term frivolous embraces both the inarguable legal conclusion and the fanciful factual allegation. The that's 490 US at 325. They cite that case right there. C Netsky 490 US. The court may therefore a claim as frivolous where it is based on an indisputable meritless legal theory. It's a theory that they call it, or where the factual contentions are clearly baseless. At 327, the critical inquiry is whether a constitutional claim, however inartfully pleaded, has an arguable legal and factual basis. Okay, so right there, the critical inquiry is whether a constitutional claim, however inartfully pleaded, has an arguable legal and factual basis. See Jackson versus Arizona. 885 F2D 639640. Ninth Circuit, 1989. Franklin, 745 F2D at 1227. The court need not accept the allegations in the complaint as true, and but must determine whether they are fanciful, fantastic, or delusional. C. Denson versus Hernandez, 504 U.S. 2533 1990. Quoting Netsky, 490 U.S. at 328. Here, plaintiff provides very little factual information underlying his claims. The preliminary hearing transcript The transcripts are from a preliminary hearing where the defendant listed is Joe Emerson, and the state court judge indicates his AKA is Nii Nee. See ECF number page 10 and 6. The court assumes that the defendant in the state court preliminary hearing is plaintiff in the instant matter. However, the preliminary hearing transcript provides the most substance and indicates that plaintiff may have actionable claims. Number 1 and number 10. However, as currently pled, plaintiff state claims rely on plaintiff's assertion that plaintiff is a diplomat and entitled to rights afforded by something referred to as the two-row wampum treaty belt. an otherwise undefined document of unknown origin or form. But that's where you all get your Bill of Rights and your Constitution and the foundation to it, and your 13 slave colonies too. That's where you got that. Today you might call it Commonwealth, but to me it is 13 slave colonies with the broken treaty. And so is a diplomat and entitled to rights afforded by something referred to as the Tuuro Wampum Treaty Belt, an otherwise undefined document of unknown origin or form. Plaintiff provides no facts or information about what rights were violated under the alleged Tuuro Wampum Treaty Belt. Even assuming that claim is actionable, the court finds that there is no arguable basis in law or fact to support plaintiff's claim that he is entitled to hundreds of quadrillions of dollars. Okay, there it is, everybody. The 666 15 zeros, hundreds of quadrillions of gold mint coin. It is not counterfeit George Washington. That is the difference between the living and you, the dead entity. It also goes on, plaintiff fails to connect the facts underlying the state court hearing to his allegation of violations of Article 6, Section 2, except I gave the transcript and everything. So, of the Constitution, violation of Article 6. So I didn't write this out, but anyways, they want it written out. The Constitution, the Tuuro Wampum Treaty Belt, international treaty laws, U.S. treaty laws, and Vienna Convention treaties of 1868. Out of an abundance of caution and given the fact that this transcript indicates that plaintiff may have causes of action arising from his arrest, the court will provide plaintiff with the opportunity to amend the complaint. It wants to give me the opportunity. And again, in conclusion, I tell you all there's not a judge that can rule on this case when they are all Bible oaths. They can only do things like this, such as this Kota and Coggins. Look them up. Because it is possible that the deficiencies identified in this order may be cured by amending the complaint, plaintiff is entitled to leave to amend prior to dismissal of the entire action. Lopez versus Smith 203 F 3D 1122, 1126, 1131, Ninth Circuit 2000, and Bank. If plaintiff chooses to amend the complaint, plaintiff must demonstrate how the conditions complained of have resulted in a deprivation of the plaintiff's constitutional rights. See Ellis versus Cassidy, 625 F2D 227, Ninth Circuit, 1980. The complaint must allege in specific terms how each named defendant is involved and must set forth some affirmative link or connection between each defendant's actions and the claimed deprivation. See the case May versus Enomoto, 633 F second edition, 164 and 167, Ninth Circuit, 1980. Johnson versus Duffy, 588 F second edition, 740743, Ninth Circuit, 1978. Plaintiff is informed that as a general rule, an amended complaint super, supersedes the original complaint, and that is cited F.E.R. Dick, Fur Dick. They're all pedophiles, see? Versus Bon Zealot, B-O-N, Bon Zealot, Z-E-L-E-T. And then that's 963 F, second edition, 1258, 1262, Ninth Circuit, 1992. Thus, following dismissal with leave to amend, all claims alleged in the original complaint, which are not alleged in the amended complaint, are waived. All claims alleged in the original complaint, which are not alleged in the amended complaint, are waived. So, C. King versus Atia, A-T-I-Y-E-H, and that's 814 F, second edition, 565, 567, Ninth Circuit, 1987. Therefore, if plaintiff amends the complaint, the court cannot refer to the prior pleading in order to make plaintiff's amended complaint complete. See Local Rule 220, and amended complaint must be in itself without reference to any prior pleading. Plaintiff is informed that the amended complaint must include all allegations and defendants. Plaintiff seeks to include in this action. The court will not look to prior or subsequent filings to supplement the amended complaint. So this is not okay, wait, one more portion. Finally, plaintiff is warned that failure to file an amended complaint within the time provided in this order may be grounds for dismissal of this action. See again that word fur dick. 963 F2D at 1260 and 61. See also Local Rule 110. Plaintiff is also warned that a complaint which fails to comply with Rule 8 may, in the court's discretion, be dismissed with prejudice pursuant to Rule 41B. See Nevigil versus North Coast Life Insurance Company. And that's 650 F2D 671 673, Ninth Circuit, 1981. Accordingly, it is hereby ordered that plaintiff's original complaint number 1 be dismissed with leave to amend, and plaintiff shall file a first amended complaint within 30 days of the date of service of this order. And that was dated on April 24, 2025 by Denise M. Cota, Cota, United States Magistrate Judge. And that is my update in the case that I took it into the federal court, and anybody can look this up on the Googler, on the whatever anything that you look on the internet with service engine, they call it. But that is my report to the community of the West Coast clans and clan mothers is if you're gonna stay scared your whole life, you ain't gonna ever stand up for nothing. You won't even stand up for your children. But I have some children that I want them to know that whatever corruption that California, Gavin Newsom, Rob Bonta, and company, and their paid off judges and corrupt system. That right here, I got your paper right here. This is called I counted coup on you, and you. This is all you can do right here is send out some some spells. Remember, it's my gold, it's my shit, it's my land, it's my resources, and you really don't own nothing. So I don't really need to go much farther in this court case. Or there, I proved my point that why do I need to go any farther when it's all my own gold? Do I really want to get paid out of my own gold through this entity of a court system? I won't look like a I don't want to look like a Hollywood Indian to you all. I'm not I'm not doing this show for the money or the gold. There's a lot of times I did this. I rode up to the forts. So there's already a court case out of New York that everybody can refer to talking about. And all of you Iroquois know the court case. You try to bury it, you try to bury me, and I'm still here alive to tell the truth into your algorithms. So I see there's a sign up here on KQBM. Yeah, they censored this court case from all of the general public. It is still censored. I haven't got no coverage from no other source of media, no mainstream media. So again, thank you all at KQBM.org, all the DJs, all your supporters and financial contributors. Thank you, yeah, very much to each and every one of you. The system is corrupt. You need to resign as a statutory agent. That's what keeps you in the system. So they put this to people that are in this system and and a way to control you. I am not under federal or state jurisdiction, and this court, through its paper or through its judges, can't order the living what to do, and it knows it, and it's trying to order me to continue to play the game. But everybody that knows I won the game right here, so I don't have to really amend anything. I can let it set as it is and let it go to its appeal, and we'll see where it's flooding at that time, and see what their gambling amounts to. How many more dead bodies do they stack up to stay on this land without true peace treaties with the original inhabitants? Since the duration of this court case, I came across one Miwok, that is the one called Shingle Springs Miwok, and it turned out that relative that I met over there at Miwok Shingle Springs Reservation was the relative of the the the, the relative that would make what is called the Indian Reorganization Act. And that relative has since realized the status of independence from the government of Washington, and also the entity de facto state of California corporate commission, that he has resigned as a statutory agent, where he was also recognized as a federal entity. That's what federal is, an entity. So federal entity jurisdiction and state jurisdiction happened to us through the Federal Indian Reorganization Act. And that is where this thing of becoming one of the 575 federally recognized tribes of today. Also, I can add on that you are a casino tribe involved in money laundering, embezzlement, racketeering, missing murdered indigenous women, missing murdered indigenous people. And everyone is playing the dead man's hand of the Social Security card. A Social Security card and the name and the number is only an account created from the drop of blood that they prick on your heel when you are barely a little newborn child. And that drop of blood creates a LLC, a INC, a corporation in that state place through the birth certificate. And now you have a ghost company. That is the dead man's hand. And you're missing murdered indigenous women, missing murdered indigenous people. So the judge here says it. Yeah, the judges over there at TJ Linville and company kept on saying this name, Nii Nee, that they do recognize the name Nii Nee, and that they did say it in the court that, oh yeah, that's Nii Nee, but they were still continuing on in fraud. The fraud upon the court is how I got them in genocide over and over. Any of you understand that playing, getting played, or playing along, letting a public defender, a bar lawyer, play for you, be your voice to the ghost blue card, Social Security card. You're not any much better than the lawyer when you understand what I'm telling you, you're not any better than the bottom feeder. When both of you are playing the dead man card and you accepted it, is when it becomes pricey. That the reason they attacked me and arrested me, West Coast clan mothers, headmen, is they are threatened by the living side. The living side upholds the true treaties that are set in stone, that are made by wampum shells, that are made by chanupa. These treaties are made for a long time, called time immemorial. It's slave talk. It's not my language. But that is my message of truth, like it says up there. A couple of days ago, I was at the Miwok Reservation. Now, a couple of weeks ago, a week to 2 weeks ago, and went to Sacramento to get these forms of statutory resignation forms at the office there at the corporate commission office is where they hold that form. They call it RA-100. RA-100. You request that form there, and it asks you some basic questions. What's the name of the entity? And the entity is your name in capital letters. That is how it is written on a gravestone. And so you want your name to be the way you spell one letter capital and the rest small letters. But you want the document from them. Shirley Weaver is the Secretary of State. You want her seal and signature of the California State Republic, and to say that your name in capital letters, the LLC and the corporation, that there is not a record of that corporation entity, that ghost, that Chidi, that Wanagi, that in that case that you end up in a court situation such as I am, when you have that piece of paper, you enter it into the court as exhibit, where they mark their exhibit, and you enter it into the court and tell them to receive it and file it. Give one to the judge and one to the DA. At that time, you pull the card that there is no more entity to prosecute in that pirate ship court. So right now, today, I I put in that that card at this court here and they were apostille authenticated that there is not a entity on the records here in California State by the name of Nii Nee, NIINEE in capital letters. when I wrote that is when this answer came from the court right here. And right there is my name in small letters to the mailing address, but on the court docket, now they have my name in capital letters again, like California State, in capital letters, like an entity again. So by submitting that affidavit of certificate of no record of Nii Nee, that there's no existence of that corporation or LLC running here in California. They kick they This is when they made this order right here. That is the force of what a non-entity does in the federal court. And so there you have it also at the federal court is fraud. There it is in black and white. So do I dumb down and pretend that I am a ghost entity to do this case with the federal entity that I know I am not under its jurisdiction? No. We let it go to appeals and let the appeals people decide of their fate. If there is articles and Bill of Rights and treaties that can bring peace to foreigners with the original inhabitants. And I believe that you will want peace with us as you are flooding and causing yourself natural disasters. Shahat, to all the listeners, the community, thank you for spending your precious time with me this evening, and enjoy your evening tea and your evening story time with me, that I could share some truth with you. And it is that you are now on a big wide reservation called USA, with expired Duns and Bradstreet numbers, expired charters, expired Bibles. Welcome to the reservation, they said. So we're all there now, trying to fight alongside some of you constitutionalists and some of you patriots that still and believe in the rule of law. So last time I came through Jackson about a month ago, it was the flag wasn't even waving there. And I raised that flag up that day at that post there. Even though I don't have no faith in your justice system. I don't have no faith in this federal court in California. And I want you guys all to see it too and know it, that if you don't start hanging these people, they're going to continue to abuse the system, the authority of it, the spirit of it, that you believe you fought for the Constitution, and they brought that fight to the Indian, and that Indian came out here. We did this last showdown here with them, and that's how you can all look at your government is the same way we look at them. They don't uphold their end. Ever since they came out of water, we say that. So, in even in the even in the court case in New York, where I filed 27 charges of genocide. Over there, I didn't settle with them, so I could continue talking about it. That that portion of it, I didn't do that because when they say settle, that means that you gotta sign a disclosure that you will take the hush money. You'll not take gold. You'll just take the counterfeit dollars, George Washington, and you will shut your mouth. You'll go over there behind the closed doors and sign those papers, and it threatens you on there that if you sign it and you are caught speaking about it, that you go to prison again. So I didn't I didn't settle with them then or any time. And there is more than one time that I have filed genocide on these states: New Mexico, Oregon, New York, and some I I just didn't care to do it because the system is broke. There's there's uh there's no reason to continue on with it when it is broken beyond repair. In my knowledge from the past times, past worlds to today, we have always defended our peace. We have always fought for our peace. In this case, again, fighting with the enemy that is a ghost. I urge all of you to stay close to your fires and seek out your clan mothers and headmen, that you restore them, that they are a supreme authority higher than these judges, and that under them you have some protection and you have um, some safety, that headman, clan mother can protect you by talking to these courts and by them at least addressing their issues, that entity knows that this clan mother and headman is superior, that it is in place at that area. But without them ever learning how to file a court case, or knowledge of how you can file a criminal case, or a civil case, I was I was not really after whatever that amount was. I just did it. I was like 5 minutes to 4 o'clock or 5 o'clock. The office is closing. Since the last time, I know I don't take the gold or the settlement, which was for mm, 11 zeros. Yeah, I think it was at the New York claim for 27 charges of genocide. That was for a lot of zeros too. I didn't know how to say that number either. So this was along the same way of thinking for me, that I'm not after the gold. I'm not after a settlement that bad. We're we're in it for the setting of the true law and the future of our children's children, that they have peace under their feet to their head. They have safety and protection from below and up above while they are here on their beauty walk on Turtle Island. So to each and every one of you, I will give the time back to Juniper here this moment, and I will take a drink of that water of life, and um, sing a song in a moment when I take that drink of water there. And yeah, again, thank you for listening on your journey here, on your beauty walk, that I could intervene and share my truth with you. The court case again is called Nii Nee versus California State et al. Corporate um, parties, all alliances, and um, it is 24-CV-3185.
Oh, thank you, Nii Nee, for sharing. And for those of you who weren't able to see what was up there, it's a sticker. It's a George Orwell quote. It says, "In a time of universal deceit, telling the truth is a revolutionary act." So, thank you, Nii Nee, and thank you to all of you warriors out there too, who continue standing in the light of the sun and expressing your truth. And I feel inspired and encouraged to continue to do that too. For all of my people who didn't get a chance to, or while they were harmed, or some kind of suppression happened through the generations of war and control that has happened to a lot of our people. So